Good afternoon, good evening, everyone. My name is Andrzej Jakubowski, Vice Chair of the ACIL Cultural Heritage and the Arts Interest Group, and I'm delighted to welcome you also on behalf of Shia Esterling, the group chair, to this webinar on the legal dimension of provenance research in artworks and heritage artifacts. The webinar is recorded and will be made available at ACIL YouTube channel. It's for the second event co-organized with the interest group on international law of culture of the European Society of International Law, and we are very happy for this fruitful cooperation. Today's meeting will be co-moderated by Łukasz Liksiński, Professor of Law and Associate Dean of the Faculty of Law of University of New South Wales and the convener of the ACIL interest group. I'm now handing to Łukasz.
Thank you, Andrzej, and hello, everyone. I would just like to briefly introduce our fantastic speakers for today. And I'll go first with Dr. Folashade Adewumi, who's a reader in the Department of Jurisprudence and International Law at the University of Ibadan in Nigeria. Her research addresses, among other issues, the international law foundations for the return and restitution of cultural property that was seized during the European colonization of Africa. Next, we have Dr. Evelien Campins from the University of Amsterdam in the Netherlands, and she was the director of the Dutch Restitutions Committee for Nazi-looted art between 2001 and 2015, and she has a wide range of consultancy experience with museums and international organizations on these issues. She also sits in the Ethics Committee of the Dutch Museum Association. Next, we have Dr. Tess Davis, who's a lawyer and archaeologist by training and the executive director of the Antiquities Coalition that is headquartered in Washington, D.C., the United States. She oversees the organization's work to fight cultural racketeering worldwide. And in 2015, the Royal Government of Cambodia knighted Tess for her work to recover the country's plundered treasures. And last but certainly not least, we have Dr. Rebecca Tusi, who's the Regents Professor at the James E. Rogers College of Law at the University of Arizona in the United States as well. And she is of Yaqui descent and widely known for her work in the fields of federal Indian law and Indigenous Peoples, human rights, and heritage. Back to you, Andrzej.
Thank you, Łukasz. And just to remind that this webinar will focus on the significance and practice of provenance research in ensuring justice for victims of genocide, colonialism, and discrimination against indigenous peoples. It also addressed the topic from the perspective of combating the illicit trafficking of cultural objects. We hope to facilitate a debate on the return of cultural objects, bringing together experts from different fields to identify shared pathways for advocacy. The format is roundtable, followed by Q&A session. But in the meantime, should you have any questions or request for clarification, please send your questions via Q&A box on your screen. And so we still start from the first general question, which we would like to ask to our experts. So the question is, how do you define, based on your work and experience, provenance research? What methods are used today? What is the role of legal expertise? What is the link between provenance research and justice? And Evelyn, maybe you could start.
Yes, thank you, Andrzej, for this chance to be first. And actually, of course, these are 4 questions, so you should interrupt me when I'm taking too long. But let me start with a definition of provenance research seen from my perspective, or perhaps even more generally. I think it's research in the ownership history of an artifact. So as opposed to the traditional focus on authenticity, where you ask the question, is it an artwork real? Here focus is on the narrative behind the object and on the questions, who were the previous owners, how that possession was lost, and how it was acquired, and were there injustices involved there? So here also already a link to the last question. So in the field of Nazi-looted art, this focuses obviously on the whereabouts of the artifacts in the period, in the Nazi period, so 1945, 1945, and on the question whether it was lost as a result of Nazi persecution. Now, this gained importance. I'm not sure how the audience is, how well informed it is, but let me just give this background. That it gained importance at the end of the last millennium, when public awareness was raised by several publications and an important court litigation on the Portrait of Wally case in New York, on a Sheely case, that raised public awareness that despite some post-war restitution efforts that were mostly at the interstate level, these were repatriations, many of the works were not returned to their rightful owners. And this resulted in the 1998 Washington Principles on Nazi confiscated art that called on states to identify Nazi-looted art and for ownership issues to find fair and just solutions depending on the circumstances. As a follow-up, only last year, the so-called best practices were published, again, at the initiative of the US State Department and the Claims Conference for Jewish Property. And again, it's non-binding. This whole field is based on soft law regulations mostly. These best practices reiterate this call to identify and return Nazi-looted art, and particularly also call for provenance research. And by now, it's endorsed by 30 states. So all this is non-binding soft law, as I said, and that's often at odds with private ownership law, and especially this is the case in jurisdictions with a civil law tradition, so most European countries. And this is also why these instruments call for alternative dispute resolutions or special panels and negotiations to resolve claims. Now, as to the methods, I would say that provenance research basically has three elements. The first being the identification of the artifacts, the second being the reconstruction of the historical facts, and third, legal analysis of ownership transfers. So as such, it's very interdisciplinary research. Now, as to the identification, although many new databases and portals have been launched to support provenance research in this field, this is quite, I mean, it has been going on since more than 25 years now. It is more complex than just checking a database of stolen artifacts. For example, the Interpol database that exists will never mention these historical cases. Just to give an example, and it involves archival research, spotting red flags, and the interpretation of gaps in the documentation. So it's time-consuming and specialized work. Another challenge, I would say, is that standards in this field tend to vary on the location of the object and when a claim is made. This is, after all, this field of soft law, and in most European countries, at least, we cannot go to court with these cases. So that means that standards remain rather vague. So, for example, the very basic question, what is Nazi-looted art, is not always very straightforward. Confiscations is one thing, and forced sales are also included since the beginning. Yet sales in places like Switzerland or the US, so-called flight assets, are less obvious. So claims on such grounds used to be denied, but this perspective has changed lately. In the best practices also, it says that all sales in the period 33-45 by persecuted persons should be considered involuntary transfers as a continuation of the theft. Adding, however, that it hinges on specific circumstances. So here you can see it's a matter of interpretation also. And then also we have the question, what is fair and just? Is that a full transfer of ownership title or a financial settlement? I would say that most cases are settled confidentially because there is this lack of access to justice also. So this complicates the development of norms, I would say. Now, the last point in this one question, the link to justice. I think in the first place, of course, it's meant to provide justice for deprived owners in terms of regaining their lost artifacts. Restitution procedures heavily rely on provenance research and the interpretation of gaps in that provenance, of often incomplete facts. But beyond restitution, I think provenance research is also important just to document and acknowledge historical injustices. And ideally, of course, this could pave the way for closure for victims by restitution or is another solution, but also enable societies to confront and deal with historical events. And in that respect, I also think of an interesting exhibition in Zurich that I think was just closed. So it was called The Future for the Past, that focuses on perspectives on the historical context in which the arms manufacturer and patron Burle built up his collection and was a kind of well, it was the start of a discussion in Switzerland about a very difficult past. So I think that is about my answer to these 4 questions.
Thank you so much, Evelyn. No, I think you brought like the thoughts for many further questions. You know, but now we can. I think Shade, if you could comment also on these questions.
Okay, thank you. Good day, everyone. So I will continue from where Evelyn stopped because Evelyn has defined provenance research. And the provenance research has shaped legal arguments in the area of due diligence because with provenance research, auction houses will now pay attention to the provenance of any art object that is to be acquired or to be sold because to avoid issues of restitution. So, and then traditionally, when a claimant in court wants to lay claim to an object, if whoever the Nigerian law, for example, says he who alleges the existence of a state of affairs must prove it. So with provenance research, the burden of proof can be shifted from the person who has come to say this artwork has been stolen. Because with provenance research, sellers of art objects would increasingly know that they have to prove how they acquired the object, and they have to prove that their acquisition method was done legally. Now, the provenance research has also ensured that the laws that we have, like the UNESCO Convention, 1970 Convention, and the UNIDROIT Convention, provenance research has made it possible that these laws can be enforced. And then we also have new laws like the EU regulation on the import of cultural goods, which requires that legal exports from countries of origin should be proved. The provenance will be proved before such goods can enter the European Union. Then provenance research has also gone a long way to impart museum policies and ethical standards. For example, if we look at the case of the Metropolitan Museum of Art in New York and the Benin bronzes, it was through provenance research that the Benin bronzes that brought to limelight the fact that the Benin bronzes were violently gotten during colonial circumstances. And this has led to increase in ethical scrutiny about the provenance, how objects were acquired. So in 2021, the Met Museum announced to return Benin bronzes, 2 plaques to Nigeria. And this decision also influenced other museums, like the decision of the Met Museum influenced other decisions like the Smithsonian Institute, which also updated its ethical policy and repatriated Benin bronzes to Nigeria. So we also have European institutions like the Humboldt Forum in Germany and the British Museum. They are faced with pressure to review their collections, all because of provenance research. So provenance research leads to institutional policy changes. It reinforces ethical standards in museum acquisitions and ownership. When we talk about the enforcement, international, okay, museum policies. I think I've answered the question.
Thank you so much. Thank you so much, Shade, for these comments. And Rebecca, if you could step in with your views on.
Thank you so much. It's really an honor to join this distinguished panel, and thank you so much for organizing this discussion. I'm very interested in the intersection with the case studies. So I am primarily a professor of domestic law, constitutional law, federal Indian law in the United States. In terms of the issues with respect to cultural heritage, indigenous cultural heritage, there are issues of tangible, what we would frame as cultural property that have provided the interface with what the panelists have talked about so far. But it's set against a historic backdrop that continues. And there are some distinctions, I think, that are really important to understanding the position of Indigenous peoples in the United States to their cultural patrimony, and the ways in which the discussion might be affected internationally are of great interest to me, but I will allow others to weigh in on those issues. In the United States, the term provenance really was not used with respect to Indigenous cultural heritage until very, very recently. It was in November of 2022 that Congress, the US Congress, enacted the first statute barring the export of Indigenous cultural objects, items, without a certificate, basically attesting to the identity of the object and the fact that it was lawfully being exported. 2022. So what happened before that time was the product of, and we're framing things in terms of colonialism, but that idea that European peoples had the category of art, fine art, aesthetics, philosophy. They could create these works, and the works had identity, material, and moral. They're housed in great museums in Europe. That whole framework was missing for Indigenous peoples. People routinely asserted that everything created by Indigenous, if you want, artists or authors, fell into that category of artifact, a primitive vestige of culture that could be housed in natural history museums in the United States. That category included ancestral human remains of Indigenous peoples that were routinely put on public display in the collections of museums, along with replicas of dinosaur bones and things of that nature. So that's the historic backdrop of this, that upon discovery of these lands that were called the New World, the discovering European sovereign got the title to the land, and everything embedded in the land belonged to them. So we had to work through that history, but it took until 1990 to get a very important statute in US federal law called the Native American Graves Protection and Repatriation Act, which Congress said, as a matter of human rights law, civil rights law in the United States, we are declaring that Native American peoples, and that is inclusive of American Indian tribal governments, Alaska Native tribal governments, and Native Hawaiian peoples, all of those peoples have the right to their cultural objects. And cultural objects is defined to include ancestral human remains, funerary objects, both associated with those remains and even those that have become disassociated, objects of cultural patrimony, which is a category for the first time ever that is defined in reference to the laws, the traditional customary laws of Indigenous peoples. What are those items that cannot be alienated from the group without the consent of the group? That's cultural patrimony. And sacred objects, items used in the ongoing ceremonial, religious, and cultural traditions of the tribe. For any of those items, a museum that received federal funding or any federal agency had to account for all of those items that were in its collection as of 1990. That took years. Some museums are still out of compliance with that, but that was the first step, because the idea was that each of those Native American tribes that were culturally affiliated to the items had the right to claim repatriation of those items. What about things that were not in those collections as of 1990? And this went to the second category, where the item might be later excavated on federal US public land or tribal land. And that is framed as an ownership right, so that any of those items that are taken from the land after that time have to be basically handled in accordance with the requirements to consult with the tribes and to essentially let them determine how to dispose of the items. Now, the third thing that that statute did is to bar commercial trafficking in any of those categories of cultural items. And for the first time, we got a federal criminal statute that has now been enhanced in terms of the penalties, which prosecuted those persons who loot what we would frame as ancestral sites or maybe archaeological sites on public lands, taking the items and putting them into commerce. That is a crime in the United States. So provenance for the first time was used to say, well, if you're selling this Anasazi item, this pot or whatever, where did you get it? Did it come from federal public lands? When was it acquired? And that was the first time in terms of the commercial trafficking that we saw that item used, or that term used. So today, in terms of the 2022 statute, it builds on the earlier UN convention that basically safeguards the illegal export-import of cultural property that was not applicable to Indigenous cultural property, because the idea was you didn't want to account for those historic injustices. They were framed as historic injustices, where items were taken from Indigenous peoples here into the museums and collections in Europe. And I actually have visited Europe, and there are a lot of items that were taken from the first explorations all the way up until that time that were, I don't even know how that is being accounted for. And Indigenous peoples here are very interested to know. The Vatican has a huge store. These items are of vital importance because of a principle of metaphysics. And I know that we're going to talk about ethics and the way it applies. But in terms of an Indigenous perspective of ethics, the contemporary descendant peoples and nations are the stewards and the caretakers of their ancestors. the time, the connection of time and people is united in place. And so therefore, a desecration of those items or removal of those items causes a contemporary harm to the descendant peoples. And that is a framework, I think, that really needs to be honored in the discussion. So now we do have a statute that says, where did this item come from? If it's being exported out of the United States, a certification process, and the uniting factor from NAGPRA all the way through what is called the Safeguard Objects of Tribal Cultural Patrimony Act in 2022.
Rebecca, if I may, because I think that there are some aspects that can be discussed in the next round of questions. So if I can stop now, because we are running out of time for this first part of our meeting, and I would like to invite Tess to comment on. Thank you so much, and sorry for interrupting.
No, and thank you. I just wanted to build on the remarks of the previous speakers by discussing some of the challenges. Given the previous speakers have so eloquently defined provenance with regards to art and antiquities, I just wanted to talk about how this chain of ownership or good title differs from those concepts as we see elsewhere in the law. Of course, proving authenticity, good title, chain of ownership, these are all critical to protecting antiquities and other high-risk cultural objects and ensuring they're not just legally, but also ethically acquired. But these tasks are complicated by a number of factors. Of course, art and antiquities have been bought and sold and traded across borders for millennia now in some contexts. They disappear into the private market for years, even decades, even centuries in some cases before resurfacing. As discussed already today, much of this movement has been triggered by colonialism, by imperialism, by war, and by other epochs of upheaval. And of course, this complicates the situation both legally and ethically. But despite these high stakes, unlike other high value assets, cultural objects don't benefit from serial numbers. They don't have VIN numbers. Or other recorded deeds of ownership. And the market accepts a level of, I think, what they would describe as discretion, what others may call secrecy, that just is not tolerated in any other sector today. And this, of course, includes the frequent use, and we should say misuse, of intermediaries, of offshore accounts, shell companies, and trust. These are all frequently and often legitimately used in art purchases, but they can be exploited by criminals quite easily. And as we're discussing today too, the governing law, whether you're talking about at the domestic or the international level, it's quite tangled, it's complex, it's sometimes contradictory. And all of this makes provenance research a very high-risk endeavor. There's a lot at stake. At best, and this is at best, you're talking about you might be dealing with a forgery. At worst, it's stolen property. Even worse, stolen property that enabled some of history's greatest tragedies and crimes. There's the risk of losing financial investments, of reputational harm, and criminal prosecution. So, I mean, because of all of this, it's quite a difficult endeavor. But I think as we'll be discussing today, there are certainly, there is a path forward and things that the art market can do, that institutions can do to protect themselves, as well as the countries and the communities that are victims of these crimes.
Thank you, Tess. I'm going to take over now for a minute. Before I move on to the next question, the Q&A, there's a lot of really cool stuff in there. We will get to them at the end of the session, so keep them coming. But I do have one quick question for Rebecca, which is more of a clarification. The 2022 piece of legislation you mentioned, is that the STOP Act, the Safeguard Tribal Objects of Patrimony Act?
Yes, that is
Right.
the same one.
Perfect. Thank you. And yeah, there's another question specifically for you, but I think we'll get to that later because it raises a lot of bigger issues. So each of you, in conceptualizing this panel, Andre, Shay, and I, we went back and forth a lot on names, and we chose you not just because you're incredible in your own right, but also because each of you speaks to different specific context, right? Or at least primarily, you speak to Holocaust or colonialism or Indigenous peoples or illicit trade more broadly. And we got a sense as we were thinking through these issues that there's a bit of a ships in the night almost kind of element happening here, in which people working in Indigenous context or really talk to people working in Holocaust context and so on and so forth. So we wanted partly to do this event to kind of invite more of an engagement. And we could see some of that already happening in the first question, but then there was also elements of we were using the same words, but really talking about very different things. So I want to ask you a bit more directly. So in working on the context on which you primarily focus, how often, if at all, do you engage with arguments, methods, and literature that belong in one of the other contexts? If you do, can you provide some examples? And if you do not, is there a specific reason why you do not? And I'm gonna start with Rebecca.
So I very much appreciate the frameworks that have come out of international law for looking at these issues. And I have to say, it's been of tremendous importance to me over my career to have the examples that many of the people on this panel have been working with for their entire career. So just the distinction between art and artifact and the ways in which we posit the rights of a creator versus the rights of a people that has been made into this primitive, entity. I think now we have a human rights construct, and the United Nations Declaration on the Rights of Indigenous People is that document that basically says Indigenous people have an inherent right to self-determination, and part of that is the right to control their own cultural heritage, tangible, intangible, use their language in terms of the definitions. So I would suggest that all of the things that we are talking about, provenance, ownership, claims of that nature, are infused with an intercultural ethic. And the example that was set in terms of time of war with the Nazis, for example, that is a dynamic of conflict and negation of humanity and identity. And that dynamic has actually affected many peoples throughout history, is still affecting them today. And it's that resonates with the moral arguments that are inherent in those frameworks.
Fantastic, thank you. Sade, same question.
Okay. We can see that the Holocaust cases, colonial cases, Indigenous peoples issues, and illicit trade, all these contexts share similar legal, ethical, and methodological challenges. As I conduct research into colonial issues, objects, there's no way that all wouldn't see issues that have to do with the Holocaust era restitution cases such as forced sales, duress, involuntary transfers. All these issues also come up with colonial objects. For example, if you take the Benin object as an example, you find out that in Nigeria, even when Leo Provenance in his book, he gave the account that in the 19th century, when he came to Africa, the Nigerian people were not ready to sell their objects, even though they may say the objects, they are the owners of the objects because they inherited them from their forefathers or forebears. These objects were seen as sacred objects that you find in the palaces and in the shrines. So anybody who feels, oh, it is my object, I can sell it, such person will be jeered at by others. And there were situations where even when somebody who doesn't know the value of the heritage has sold it, you find the elders in the family trying to see a way of getting it off the person by offering a higher price. So you see issues of forced sales, and then we know that the Benin expedition was a case where the objects were taken away forcefully from the people. And, when you talk about methods that are used in tracing Nazi looted art, such methods are also used in colonial and indigenous artifact research. And for example, the restitution of Benin bronzes had to do with tracking European auction records and missionary accounts, which is also similar to the research that is used on Holocaust era looted art. Then when we talk about arguments of moral restitution, rather than using strict legal proof for restitution of objects, you find this in Holocaust cases as well as in colonial object restitution requests. So when we talk about creating market awareness about this object, provenance research in illicit antiquities trafficking also draws on methods that is used in Nazi looted art research. When we talk about forensic imaging, object tracking, in short, even though this each restitution context has its own unique legal and historical aspect, myself and other researchers, legal researchers, will definitely engage in arguments and methods that cut across all these fields. And the more we collaborate on efforts to return stolen or looted objects, the more we will also promote ethical collection and then establish new methods by which we can improve on the ethical standards in a way to ensure that there is cultural justice in restitution cases.
Thank you, Shade. I'm going to go to Evelyn next.
Thank you, Lucas. Yes, I think it's very important to zoom out for us all, to look at the field as a whole, and because then I think also if you do that, and I try to do that also, you come to basic questions. So what is the reason for this paradox that looted cultural objects can be lawfully acquired or possessed, and what is the practical? Well, Tess already mentioned that is this identification problem, and that there can be this trade in unprovenanced artifacts, but there is also the legal question. So that comes down to the question of ownership and perhaps property rights as we use it as an economic right. Maybe it's not very suited for cultural property. And I think this, for example, becomes clear when one thinks of just a return last week in the Netherlands of Benin bronzes, of a large number of Benin bronzes, on the soft law policy that we have in place now also for colonial era takings. And there were like 120 Benin bronzes, and one has not been returned because it was at the same time it's claimed by an heir of a Jewish art dealer. And actually I have seen these cases before, so these loot in loot cases, and this brings you to the question, I mean, of ownership, and also what Rebecca also mentioned is community property and individual property. And these are problems that are that can be that come up. I think that from these other fields, more specifically, for example, the field of Indigenous Peoples rights and cultural objects, I think this whole human rights approach is really useful, and the possibilities of the human rights framework. so to get around these property law issues, I think that's really interesting, and the acknowledgement also of sub-state right holders to cultural property. So in the field of antiquities, it's normally states, national patrimony. In the field of indigenous peoples, it's indigenous peoples, so communities are acknowledged. And in the field of Nazi-looted art and more general, it's families or it's individuals. So, and this can clash. These claims can clash. So maybe we have to go towards another forum there. But this also came up in another case that was just decided in the Netherlands concerning colonial takings, where the framework is for an interstate approach. So in Europe, we have for the moment, for these colonial era takings, we have an interstate system, like the antiquities, like the 1970 convention. But this concerns the restitution of artifacts to the Isleta del Sur Pueblo in the US. And they filed the claim themselves. So they had, fortunately, the US government supported the claim. And in the end, it was returned to the US for the Pueblo. But here you see already this development, and I think that's really interesting, of this indigenous peoples' rights and the human rights framework, this possibility to acknowledge sub-state right holders. Yeah, and I can continue with other nice examples. Maybe I should leave it here.
Thank you. It's great to know there are so many examples of effectively a type of intersectionality among these domains, which kind of forces that confrontation, right? Tess, over to you.
Yes, just to build on the wonderful comments thus far, I think there is certainly such a need for more dialogue between all the different perspectives here today. This is something I have discussed many times over the year with Mark Mazerovsky, whom I'm sure many of you on the webinar today and in the audience knows, co-founder of the Holocaust Art Restitution Project. That on the one side, the art market, museums, these are pretty, in many ways, unified groups. They're professional associations that cut across countries and parts of the world. They're often corporate, so they're very well organized. And yet there are, not these same opportunities thus far, though today is a good start for those working with indigenous people or with Holocaust victims or with, source countries on the illicit antiquities trade, to talk to one another, to organize together, and to come forward with a more unified voice against the groups that are opposing restitution. I think another practical problem that this field faces, and we certainly see this with regards to the illicit antiquities trade, is that so many of the resources for provenance research, so many of the training and excellent training and educational programs exist for it, but it's very much a Western art-centric stance, training in French and German and Italian, which is not necessarily, and for fine art, which is not necessarily helpful for, say, combating the illicit trade in Cambodian antiquities. There's just a big gap in the skills that are actually helpful and the training and resources that exist that I think the field is just starting to catch up to, if at all.
Thank you. Andrea, over to you.
Yes, thank you very much. So, because the next question, the next topic I would like to address was to some point was already tackled in and addressed in your talk. So basically, the question what impact does provenance research, its methods, standards have on current practice of law, particularly in the context of international art trade and museum policies, and you addressed in your talks some of these questions. So my request would be to give some good examples, some examples so that you could share with the audience. And also, I would like to address two comments from the Q&A box concerning the documentation, so the evidences. So the one question is, why in cases we do have a good documentary, the good evidences of the loot, of the illicit removal of object, and there is no restitution, and in particular in the colonial context. And the second is what to do in those cases in which indigenous art was removed from its original community, from its original territory, to a different location, and there are no traces, documentary traces of that removal. So what to do? How to do provenance research to trace the provenance, so the origin and provenance of that objects. And the last question, very much linked to also to the practice of the law, and is the question of statute of limitations. So whether the claims for restitution should be time-barred, should be an exception for particular categories of objects. So if you could answer these general question on the impact of provenance research on legal practice, but giving some examples, and also maybe to link to those questions from the chat. And please let's have it this round of answers quite concise. Thank you. And maybe Tess, if you could start.
Yes, well, just to start with the question on the chat of that, even when we do have proof, and I think this is just, repatriation is very difficult. Any time a piece goes back and it makes the front page of the New York Times, there's often these quotes from curators or museum directors saying that, oh, the museums are all going to be emptied. That, of course, is not the case. These returns are by and far the exception, not the rule. Cases are very difficult to prove. And despite the fact that we frequently say that at least in the common law systems, a thief can never transfer good title, it happens all the time. What's the value of good title if you can't enforce your ownership rights? And because so much of the law is retroactive, because there are these procedural defenses like statutes of limitations and latches, we have this disconnect between, on the one hand, especially with regards to antiquities, most countries, Switzerland and the US, are frequently held out as exceptions. But even in the US, we have a patrimony law for federal land, which is a third of the country. State ownership of antiquities in the ground is a pretty well accepted legal proposition in just about every corner of the world. But this exists with an equally ubiquitous private market in cultural property, because there's this disconnect between what the law is on paper and whether you can actually enforce it, and the fact that so many of these laws are not retroactive. So enforcement is really difficult. On the one hand, ownership laws are very strong. On the other hand, if you can't enforce them, what's the value of having good title to begin with?
Thank you so much, Tess. And now, Evelyn, if you could comment on that.
Yes, thank you. Yes, I think it makes me think, these questions all make me think that provenance research is, I think the development is going towards a situation where increasingly provenance research, so minimum standards of ownership, of documentation on the ownership history and a good title, let's say, increasingly this is decisive for the legality of a transaction. That is, and I'm saying if you look at restitution cases simply from the perspective of ownership law and ownership title, you run into many problems, like the problem of retroactive activity, non-retroactivity of old cases, like the very well documented cases in colonial times and identification, etc. The laws are not retroactive, there are time limitation for ownership claims. So you should do it the other way around. And I think I see that development in certain regulations, that you cannot, you shouldn't be able to trade anymore, to acquire or to put on the market, to import cultural objects if they do not have a good ownership history, so a good provenance, and then you block this everlasting and vicious circle, and there, with doing that, you can circumvent these problems raised by legacies, by time limitation, by non-retroactivity, because then you basically stop they become in a field where they cannot be traded anymore. I think that's the importance of legal developments in these fields. If you want me to name examples, I can do so, but probably want to go on to the others.
So maybe we can keep maybe some examples to the end of the meeting. But now Shad, if you could comment also on this new development, you know.
Okay, thank you. So concerning, I think all of the questions you said are raised in the chat box has to do with how do you identify objects when they are stolen in colonial context. If you think so, the objects that are okay, I have a scenario. I have a colleague here that some objects were taken from the palace in the village where he was when he was young. So he is one of those who stay in the palace. The Oba of his of the Ilobu community is his uncle. So when he was young, he knew when the object was taken from the palace. Now that he is an adult, he's an archaeologist. So he went to the Louvre Museum and he saw the object. So he looked at it and he could remember, memories of when the object was taken. But if we go through the 1970 convention, the 1995 UNIDROIT convention, even though they are not retroactive, but they have specifically mentioned that inventories is very important in recovering stolen objects. So what African countries, the main problem we have is that we do not have up-to-date inventories. So if we can have inventories or make use of the object ID standard in inventorying heritage objects, when these things get missing, then Interpol and the custom authorities will find it easy to help in retrieving objects that are stolen. Also, museums and auction houses, they will be on the alert and they will ensure that due diligence is adhered to before they purchase any object. So if I go back to the main question that the methods and standards developed, what effect do they have on current practice of law? I said that provenance research really is helping a great deal in the current practice of law because it helps in strengthening legal claims for restitution. If you are able to trace the history of the object and show that this object was taken from your territory in a way that is not legal, it will be easy for you to either put up moral pressure. For example, when we talk about the taking of objects in colonial times, imperial laws, the imperial laws that were in place during colonial administration could point to the fact that the takings were taken in legal ways. So this could also make one come to the conclusion that, yes, the laws that we had at that time were the written laws that we had in Africa, Nigeria, were made by the colonial masters. And then, in the laws, you can only export antiquities if you have a permit. But those laws were there, put in place for their own good, not for our own good, because traditionally, these objects, antiquities, were held sacred, and they were not things that should be sold or taken away because of the significance that these objects had to the local community. But with provenance research, courts can increasingly accept provenance research if there is a case before the courts for restitution. And it will be easy for custom authorities, the Interpol, and prosecutors to rely on provenance research while they are trying to build up their cases concerning theft of objects and issues like that. So like I also said earlier, auction houses, art dealers, they have to make sure that all the objects that they deal in have provenance documentation. They're able to trace the history to show that the objects that they are transacting in are objects that are legal. Yeah. Then museum policies, ethical guidelines have also been affected by provenance research. So you have, for example, in 2022, I think 2022, yes, the Smithsonian Institution adopted a policy to return Benin objects, looted Benin objects. And then we see that the British Museum, the Louvre Museum, they are still undergoing pressure to return colonial artifacts because of this provenance research. So, many museums, they pay attention to provenance research so that they can make sure they have guidelines that will favor restitution of objects or help in making sure that the objects that they are collecting are being collected in ways that will not violate, in ways that are legal, or putting into consideration ethical standards in acquiring objects. So I think that is
Okay, thank you so
all I
thank you
have.
so thank you so much. Thank you so much, Shade. And I would like to ask Rebecca, because Rebecca, I think the question that is very much linked to your expertise, also from, as I mentioned, from the chat, the question about the methods of provenance research in those cases when there is no documentation. So basically, with the objects, indigenous people's heritage was removed from the site and was taken to a different location. There is no documentation how to prove that was taken from a given community and from given land. So what new methods of provenance research can be used to prove this link and the origin of the object? Thank you.
Thank you. That's a great question. And I'll just give a brief answer with great appreciation to the colleagues who've spoken. So NAGPRA actually did a huge service to the relationship between museums and Indigenous peoples by setting up a protocol where the museum had to list all of the items that were in their collection, and that required them for the first time to look at that documentary evidence about when the object came into their collection, where is it housed now, that whole history that is associated with provenance research was unknown before that statute issued that requirement. But the second thing it did is to say, in identifying the items, they really have to consult with potentially culturally affiliated Indigenous peoples in the United States. And so that set up the practice where the cultural knowledge is still very intact in many, many Indigenous peoples in the United States. So they would go and identify things that the museum had no idea what this item was, what group it belonged to, what the practice was. Nothing. They just knew it was Indigenous from the Southwest, whatever. And so the knowledge that came out of that was very, very important. And that's an example of what I have described as that intercultural process that is necessary to understand the significance of an item. So the purpose of the item, if it was cultural patrimony, it needs to go back to the people. It's emblematic of their identity. It needs to go back. If it's a sacred item, it may have duties and responsibilities that the people have toward the item. Maybe it shouldn't be on display. Maybe it shouldn't be touched by certain people of whatever, is antithetical to the energies of that particular item. Museums were not used to thinking about stewardship as being anything other than preserving the item for public display or the museum's purposes. If it is something that is a living item, and many of these cases, the Indigenous people would say that that item is living. You have to feed it, you have to care for it. You can't just have everybody schlepping it around and loaning it to other places. It needs to be in its place. That ethic of stewardship is currently embodied in the federal regulations, but they're barely a year old. So it took that long for the museum practice and that intercultural set of ethics to catch up. And the last thing I'll say about this is the provenance claims, and one speaker alluded to the fact that under national law, since 1906, if somebody is looting archaeological sites on federal land and taking pots and remains and whatever, that's a federal criminal crime. But you didn't know that until the museums had to do their inventories and to say, where did we get these and who did? And then you get the notorious contemporary looters, which is why the penalties are quite enhanced. But there was effort, and you'll see this in some of the early cases by those collectors, amateur archaeologists, to say, this is part of American history. We just thought it was a mask. We just thought it was an Indian skull. And everybody knows that you can collect that stuff. And that's a desecration. So I think our national conscience has come into being where it's no longer acceptable to do that. And that's the reason for these enhanced penalties in current trafficking.
Thank you so much for all this answer in this round of questions, because you really showed the linkage between the law and its practice, and provenance research methods, So going from documentation into anthropological research, into stewardship, as you said, Rebecca, and all these different layers. And I think this was very important to explain all these intersections. So thank you very much. And Lucas?
Thank you, Andrea, and thank you, everyone. I sort of want to get us back to the question I was asking before and think about it less conceptually and more practically, if I can draw that clear distinction. And I want to ask essentially about coalition building, right, among Holocaust return kind of advocates, colonial return advocates, indigenous return advocates, and illicit trade kind of advocates more broadly. And see, what do you think about the possibilities, promises, and pitfalls of coalition building across these four spaces with an eye to restitution? So that's kind of the basic question, and I want to ask Sade to go first. But before I let Sade speak, I want to complicate the question a little bit more, based on some input from the Q&A session, which is going really, really well. By the way, keep them coming, everyone. So we had two similar questions, or two questions that speak to one another, and I think fit well here as potential examples of coalition building. And they have to do with this kind of distinction we still draw in the law and in these fields between property and heritage, right? All these four fields, or these four sites of advocacy, they seek title, right, in one way or another. So you would think they would default to the category of property, which is what US law still uses, contrary to the rest of the world, which has kind of largely moved on to the idea of heritage. And yet we still talk about it in terms of heritage, which gets us thinking about the sort of the non-private or the public-looking kind of dimensions of these returns. And it was a question specifically by Devin Dowling, who was kind of thinking about conditions that can be attached to the return of these items, like that it cannot disappear into private collection, right? That it must be viewed by the public or go on loan to museums, and that researchers be allowed access. So in thinking about public and private property and heritage, are there sites for coalition building that can think about can help us think through conditions of return? I suppose that's the way to kind of tie it all in a bow, and hopefully I haven't made this too complicated. But let's see if it is too complicated. Shade, do you want to give that a go?
Okay. Oh, well, I would start by saying if there is coalition building across a Holocaust era restitution, colonial era looting, indigenous repatriation, and illicit trade. If there's coalition building, it will make it possible for stakeholders to come up with a universal legal framework that may be able to work for all these four contexts. For example, if you look at the Washington Principles on Nazi Confiscated Act of 1998, it sets out ethical restitution standards that have influenced debates on colonial heritage and indigenous repatriation. So, since we have some kind of nexus to lead to a situation where we have a universal legal framework that we can use for restitution of these objects taken in different contexts. And it will also lead to a situation where we have a provenance database of open access provenance database that it will be easy for people to know the provenance of objects, and you can these objects taken in the four contexts, we can look at them from the angle of restitution in a way to ensure that there is global justice, And if you look at it in this context, we can look at, for example, the Guinea objects and other colonial era looted at. It is the momentum that is behind the Holocaust era restitution that is helping to pave way for repatriation or return of Guinea objects, even though we are mounting up moral pressures for that. And it's not like we are using the legal methods to ask for repatriation of Guinea objects. We are making use of moral pressure. And at least it is because Holocaust cases, a lot is moving on in that era. That's why we are also making, I can say that's why we're also making progress. The pitfalls, when we talk about pitfalls, if all the objects that are in these museums are to be returned, there will really be issues. So for the Holocaust cases, those ones are going on through legal means, while we for return of the new objects, we are mounting moral pressure, looking at the ethics or the morality of foreign museums holding on to this object. So there may be institutional resistance for the return of colonial era objects. And then there are times when, even though, these objects were taken within different historical and cultural narratives, so it may not be so easy to make sure that these objects are returned using the same pattern. But there's no way that the moving together or working together of researchers in these four different contexts will actually go a long way in bringing about public awareness as to the injustices that communities have encountered from the Holocaust cases, the colonial era taking, the indigenous repatriations and illicit trade. So when we come together and we work together, definitely we will achieve a lot more than working individually in relation to all these concepts of injustices perpetrated on different communities.
Thank you. Tess, same question.
Yes, well, just to pick up on your point about cultural property and cultural heritage, of course, this goes far beyond, just mere semantics, that property is so associated with ownership, whereas, heritage is associated with this collective responsibility. And, we treat them, I myself as well. And I know you, both of our moderators today have written extensively about this. We often treat them as synonyms when they're inherently contradictory. And so this is, I think, a challenge that goes beyond just the words we use to the conceptual frameworks we use and how we enforce it, especially for things that might not lend themselves to an owner or to a closed universe of owners that we see. Now, how to reconcile this today? I think it's a problem. We haven't talked much about. We've talked a little bit today about the difference between state actors and sub-state actors, which I think is an emerging crisis in many ways in the field. If cultural property and cultural heritage are at odds, then of course the same is true of state property and world heritage. There are two arguably opposing concepts that we treat as synonymous. And I don't think international law has really figured out yet how to thread the needle between the two. I like the approach of the Italian scholar Manuel Frigo, who says, both have their place. We have cultural heritage, which is the bigger field, and we protect that by protecting, these things that we can narrow in on the cultural property. And so I think there are ways to thread that needle, but it's a hugely important discussion with real world impacts that we're still seeing playing out in many of the crises around the world today.
Fantastic. Thank you very much. Rebecca.
Oh, I would like to follow up on that comment and really appreciate, Tess, you framed that so nicely. When I started doing the work on repatriation right after NAGPRA was enacted, and there weren't any regulations yet, and so part of the challenge was, what meaning were we going to give to these larger issues? For example, museums said if we allow too liberal of a standard for repatriation and cultural affiliation, then our collections are going to disappear, and that's going to be a harm to the American people. And that whole contested notion of cultural nationalism and cultural internationalism that Merriman wrote about, that was inapplicable to the quest of Indigenous peoples as peoples to reclaim their history, their identity from the vestiges of the colonial frameworks of discovery and ownership. So it was really to liberate that and to come up with an Indigenous conception of what cultural heritage means to Indigenous peoples that are rooted in place, that is a universe that is timeless in many ways. The United States appropriated that heritage for its domestic museums. And so today, I think the tribal museums are doing a wonderful job of interpreting the culture and museum practice in ways that are very responsive to the needs of people. And the culture is more visible in many ways now than it ever was in some glass case in a museum prior to NAGPRA. So if our interest is really in understanding who the people are and in their collective context have always been, I think that the work that is happening with previously colonized nations in terms of self-determination is also applicable to the framework of indigenous nations within the United States. But that is still a process, I think, that has to be mediated by the concepts of art, artifacts, cultural heritage, and property. Cultural appropriation also happens with Native artists who create fine works of art in the current day, and yet they have these mechanisms of stealing designs and counterfeit. So the idea of authenticity and art is still important, but that's another statute, the Indian Arts and Crafts Act. So the Indian Arts and Crafts Act and NAGPRA actually serve a twin purpose in checking that dynamic of cultural appropriation that has been going on for a very long time.
Thank you. And Evelyn?
Yes, there were so many good things already said by the previous speakers, and I think we don't have much time more. That I just want to say that I think it's really important to work together and to find these commonalities. And I think, well, the difference between heritage and property is very important, because I think in all these categories we talk about now today, it's about kind of heritage value, which is well, what is in a piece of property, and we're trying to squeeze this into this property regime, and that may not be the right regime. And yeah, that's I can go on a lot, but I think let's go to the questions and leave it there.
Super. Thank you very much.
Maybe I
Oh,
can one last remark that came up and I forgot, is that it's also in the field of Nazi-looted art. It started out as family artifacts, so heirlooms, and in the best practices also this focus is very much that it's also about community-owned Judaica. So again, it's this heritage factor also in that sector, and that was it. Just to add to it.
fantastic. Thank you very much. So from the Q&A, we had some specific questions about some very specific contexts, like very famously the Koh-i-Noor diamond affecting India, but also Pakistan, Iran, Afghanistan, and a number of other countries that have established claims. So I would like to hear if you have any thoughts on the Koh-i-Noor diamond as something that is about a colonial context, but then there's also like an indigeneity element depending on which country is the claimant. And of course, it's not something that is clearly covered by the rules, but in non-retroactive international law. So there's a whole thing about ethics. So anyway, if anyone has any thoughts on what our discussion today can help us do in relation to the Koh-i-Noor diamond.
And if I may, I just one question also from the chat concerning the representation of different claimants. So I think this is also important, because in relation to indigenous people, but more generally the role of of the communities. So Lucas, also it's your topic now, of communities asking for restitution, and they place in the negotiations, in the place in claiming for the access to provenance documentation, to access to archive inventories, and so on and so forth. So what is the authority of those communities, heritage communities, especially in cases if these are not supported by state authorities? Thank you. So who will start? We've got 10 minutes.
Easy peasy. Yeah.
No. Evelyn.
I was thinking on the last question, the UNDRIP, of course, United Nations Declaration on the Rights of Indigenous Peoples is also, that's also what I meant with this last decision of the committee on with the US return to the Pueblo. It was also, the reference was also to UNDRIP. The US actually referred, so they supported the Pueblo, so the tribe, in their claim that actually was already made in the 1960s and was denied all the time. Until now we have this policy framework, but it was a bit the committee was a bit confused because it should be a state that makes a claim. It's the interstates. But then the US government referred to UNDRIP and that they supported the tribe. So, and I think this you see in more decisions in Europe, that this entitles indigenous peoples, also tribes, by themselves to their lost cultural property, cultural rights.
Thank you so much, Evelyn, for these comments. And as we know, there's also in practice, in this international practice, there are more and more cases where there's new framework for the communities to ask for institutions from different. So we can give an example, especially from Latin America, so from Colombia, from Mexico, but obviously, for instance, in Europe, this is still problematic in many ways. So basically, communities are excluded from restitutions negotiations. Tess.
Oh, yes, I just thought I would chime in about cases like the Kohinoor Diamond and others that may be beyond the reach of our contemporary law, at least. And obviously, these are some of the most pressing issues in the field. I mean, some of the star cases, the Elgin, Parthenon, Marlboros, et cetera. From our perspective as an organization that supports communities and countries around the world who are working to recover their stolen property, just wanted to stress that, the law is only one part of a success strategy. And something that we've seen in particular with the royal government of Cambodia and its quest to recover its stolen property, so much of which was looted during the killing fields, but also other periods of upheaval during the country, is that successes tend to lead to more successes. And so Cambodia initially focused its efforts very narrowly on the cases where they had the strongest chance of success. It wasn't necessarily the most famous pieces, but those that could, were clearly taken, against national law at the time in an area of armed conflict. And the success that they got, it started the ball rolling that has allowed them, I think, to broaden those scopes to other pieces. The law remains a hugely important tool, but so many of these recoveries and repatriations are not legal, but political. And when the political will is there on the behalf of the country or community that is seeking the request, when it's there on the country that might have it, we see these creative solutions become possible. And so hopefully the more awareness that is raised from the cases that are happening now will slowly chip away at the hesitancy of some of these, museums and others that are hanging on to these pieces that were clearly taken, again, if not, if under the color of law, against, any law that we would hold up today, let alone ethics.
Fantastic. Thank you. There's so much in the Q&A. It's a really rich, enthusiastic conversation there. So thank you everyone for that. I've been frantically trying to answer a lot of the questions. We're very quickly running out of time. So I'm just going to turn to each of our panelists and ask you for final thoughts, or if you have one sentence that you wish us in the audience would take away from this conversation and the bringing together these perspectives, what is that message? And I'm going to go with Evelyn first.
Oh, a sentence. Well, I think I really wanted to mention the Getty bronze case. That is so interesting, because it opens up, I think, the older cases. So we're talking all about historical cases, and the law is closed there. But the European Court on Human Rights had more or less retroactively applied their due diligence standards for provenance research and said that an acquisition already before there was a legal framework was not correct. So this opens up, I would say, a whole new field perhaps. So there's hope for older cases in that through this human rights avenue perhaps. So
All right, thank you. So there's more power in human rights, which we haven't really tapped into, but there are some late questions in the Q&A about that. But anyway, Rebecca, final thought.
So the UN Declaration opened up the conversation about Indigenous peoples as peoples with an S, with the right to self-determination. And many Indigenous peoples exist across international borders, which position that idea of, well, if Canada has this policy on repatriation and the US has this policy on repatriation, and maybe Mexico doesn't have a policy on that serves the contemporary tribal units as sovereigns, what do we do then? And that could become gridlock. Don't do anything because you don't know who the appropriate claimant is. But I would argue that Indigenous peoples have made a practice, according to that human rights-centered view, to work collaboratively to actually get items back to the places and societies and clans and peoples that they should be with, because they are still part of the living culture of those peoples. And that has been very inspirational. And I agree that it is a political dynamic. It is not something that is required by law. But I really commend the European institutions that have welcomed Indigenous peoples to come through their collections with that. And in some cases, it's been representatives from both the US and Canada where those peoples straddle the border. So that's very forward thinking.
Fantastic, thank you. Shade, final thought. You're on mute.
Okay, thank you. Parting comment. I just want to say that on the 12th of February, the National Commission for Museums and Monuments signed an agreement with the Oba of Benin concerning the repatriation of ownership of the Benin bronzes. I am aware that after the declaration, the gazetted law passed by the former president, there has been a lot of comments, opinions that the Benin bronzes will now belong totally to the Oba of Benin. So this agreement signed by the National Commission for Museums and Monuments is just to put at rest all these different opinions and make it clear that there's no dispute between the Nigerian government and the Oba of Benin concerning ownership of Benin bronzes. The bronzes were taken at a time when there was no Nigerian state. But since under international law, well, the federal government has been going about, long before now. The grandfather of the present Oba of Benin started the moves towards repatriation of Benin bronzes. And the federal government has made a lot of progress before that law was passed. So the agreement now is to put at rest everybody's mind that the bronzes are not, there's no way that the Oba's palace, can totally contain all the objects that are being returned. So some will be in the palace, some will be in the museum, I
Thank you.
believe.
We have a very hard out, so I will have to cut you off. I'm sorry because I could hear about you talking about this for days. And unfortunately, we will not get to TAS. But thank you to all of our panelists and everyone in the audience for a fantastic discussion. If you want to hear more, if you want to engage more, reach out to the Cultural Heritage and the Arts Interest Group of the American Society of International Law, or the International Law of Culture Interest Group of the European Society of International Law. If you're not a member of either society, you have a great incentive now to join so you can continue having these really important conversations. So please all join me in thanking once again our fantastic panelists. And I look forward to seeing you all many more times in the near future.